I call Reno Turakardini. Tēnā koe.
Thank you, Mr. Speaker. I'm pleased to take a call on this Civil Defence Emergency Management Amendment Act 2016 Amendment Bill. And, Sir, I don't want to traverse the territory which has all been covered. We know the background as to the introduction of this legislation, albeit missed by about 4 days, so we're activating the transition period now. But, Sir, I want to pick up on a point which Mr. Parker raised, and this is just in relation to the rights to appeal, and I'm sure we'll be able to pick this up in later stages. But I just want to flag the House's attention to Section 77 of the Principal Act, which is amended by Clause 8, Subclause 7 in the bill. And so, when a building owner is required to deliver up a building certificate, and there are various tests which are laid out in that section, Sir, but there are rights of appeal for the building owner to appeal it to the District Court on the grounds of unreasonableness. And I just want to flag, and I'm sure it will be picked up later on, but in Section 77 4, it states in the Principal Act that an appeal against a requirement to give information operates as a stay of the requirement. Now, surely, on the face of it, Sir, whilst a building owner may appeal, that the obligation for them to still provide the information should still stand. They should still be able, but should still, in spite of the appeal, be required to deliver up that information. And so I just wanted to raise that briefly, and I know that that might be a matter which will get further attention as we progress in the later stages, Sir. But apart from that, Sir, I do want to focus, which has been the focus so far, on the directions to building owners to provide safety inspection certificates and building assessments, Sir, because, look, when we look back to the Christchurch earthquake, one cannot help but think of all of the victims that were in the CTV building, Sir, and 75% of the fatalities in that quake occurred in that one building. And I believe it was 117 odd Kiwis and international students, people lost their lives. So I think safety should be front and centre, in particular safety of our buildings, just purely in light of that shocking statistic which we have come through with the Christchurch experience. So I don't want to, bring a sombre tone to the debate, Sir, but I think the safety of tenants, those who occupy it, if building owners are not supplying information or giving that reassurance when the controllers in an emergency situation or in a transition situation require that information to be delivered, they should deliver that information. They should get the work done, irregardless of the cost. And I know that there are tests that are prescribed in this legislation, Sir, so there are the checks and balances. There is, it must be proportionate. So I think there is great care has been done, but I do believe, Sir, that we need to focus on the rights of appeal and whether the provisions match up with the actual primary bill itself. But apart from that, Sir, this is a very good piece of legislation. We're just accelerating the introduction of legislation which has already been fully debated just a few short weeks ago. And but the addition, Sir, of the requirements for building owners to provide that assurance, to do that extra, provide those extra reports, is very important. When we look in Wellington City, it is evident that if a building's not safe and if a building owner is shirking on their responsibilities, they should be compelled to do the right thing and deliver up that information. So, sir, I'm just going to conclude it there, and I commend this bill to the House.